and Trends by Stuart Paterson. Stuart is managing partner for the Middle East at Herbert Smith Freehills, and Omar, who you've just heard from, Omar Swaf, an attorney with lots of international experience, but to our benefit, now residing and working here in Michigan. Omar will introduce Stuart. But before we go forward with that, a couple announcements. Number one, I would ask you to all please mute yourselves if you are not presenting, commenting, or asking a question. You can submit questions via chat as we go. That seems to work well because then we have a record of the order of the questions. We don't forget what questions have come to mind. And in the event that you have trouble with your audio or video, we can introduce them for you. So I encourage you to make note of questions you have or topics you might want to comment on in the chat as we go. We'll all be able to see those comments, and I can interject them if you can't. This is scheduled to run until 1 p.m. If we finish early, that's fine. So Stuart, feel free to present for as long as you like. I will give you a 10-minute warning, so to speak, at 12:50. And if we haven't already had an opportunity for a collective discussion with questions, we'll have it from 12:50 to 1 p.m. At 1 p.m., I will formally bring the meeting to a close. Often, these presentations elicit a continuing discussion. And Stuart, you are, of course, free to drop off at 1, as is everyone who, many of us probably do have following obligations. So feel free to drop off. I will stay on, and anyone else who wants to stay on is welcome to do so and continue the discussion. But if you have questions for Stuart in particular, I encourage you to ask those before 1, because Stuart will probably be leaving us then. Is there anything else? Yes, let me introduce ILS Council member Omar Swaf. So you saw Omar briefly there just before we began. Omar is the person who you may have heard introduced us to Stuart, and we thank him for that introduction. It's wonderful. One of the silver linings, if one can speak of it that way, of this COVID-19 era is that we have this opportunity and we've become accustomed to hearing from people around the world. And this year at ILS, we've taken full advantage of that. And this is a continuation of that pattern. So I'm really happy to be able to hear from an expert, Stuart Paterson, from another part of the world who's done things in places that I have not personally been. So with that, I would like to turn it over to Omar to introduce Stuart. Take it away, Omar.
So hi, everyone. Just an introduction. Stuart is head of Middle East dispute resolution for Herbert Smith Freehills. Herbert Smith, if you haven't heard, is a global powerhouse and has one of the strongest dispute resolution practices in the world. Stuart is experienced on all aspects of dispute resolution in a variety of sectors. He's also ranked by various organizations, including Chambers and Legal 500. I worked quite closely with Stuart during my time at Herbert Smith Freehills' Dubai office. He's a great lawyer and a good friend. So, Stuart.
Omar, Elliot, thank you very much for those very kind introductions. It's a pleasure and a privilege to be speaking to you all today. And Omar, thank you in particular for those kind words and the powerhouse, as you've described. HSF is all the less for your departure, but what is our loss is the Michigan Bars game. I have intentionally made my presentation pretty high level to facilitate a discussion. So I'm very keen, as Elliot has encouraged, for questions to be raised at any point during the session. So please do use the chat function as indicated. I am probably not the kind of person you necessarily expect to be speaking to you from Dubai in the Middle East. I'm a British lawyer, English qualified, and that is probably not what you'd expect to find in somewhere like Dubai, which is an Arab Muslim city. But I'll tell you a bit about that a bit more in a moment. But my journey is that I started off at Herbert Smith Freehills. It was Herbert Smith back in the day, back in 1998, as a graduate lawyer, I suppose you would call it. And from day one, it was obvious that everything was becoming increasingly international, and I got the travel bug very quickly. I did some of my time as a graduate lawyer in Paris. My first case as a qualified lawyer involved a dispute acting for a bank in Saudi Arabia. And I was able to, I had the opportunity to fly out to Riyadh, the capital of Saudi Arabia, and to interview some very wealthy investors who had put some money into a big property development, to go to the bank and to go to their homes and to just explore this extraordinarily different and fascinating culture as a very, very junior lawyer. And the bug just hit me from there, really. And I then sought out every opportunity to do things that would expose me to more cultures and legal systems and the like. And so I've had the chance to work around various, mostly emerging jurisdictions. So the Middle East, where I've been for the last 12 years, but also lots of work in the ex-USSR, the CIS states, and other parts of Asia. And I guess that means I've always had a very international perspective on how to resolve disputes and the sorts of issues that you need to be thinking about when you're going into a transaction with a foreign counterparty that might be different compared to doing a transaction with a domestic counterparty. And we'll pick up on some of those issues as we go through the session. So we will get on to the content in relation to applicable law, jurisdiction, and enforcement of judgments in a moment. But just to give you a bit of a perspective from where I'm sitting in Dubai, I was asked by my boss, the head of dispute resolution, as she then was back in 2008, if I'd be interested in an overseas posting. And I immediately said yes. And when Dubai came up, given my experience in Saudi Arabia many years before, I was very happy to go. And at that time, the Middle East and the UAE in particular was going through an enormous upheaval, a debt crisis. There was litigation left, right, and centre as the Middle Eastern governments, including the Dubai government and many large contractors, developers, other large private businesses were struggling to meet debt obligations as confidence in the market crashed. So there was a need for more disputes capability. So I came out and it was fantastic. I've been extremely busy doing very interesting disputes in a really challenging and fascinating part of the world since then, since 2009. And that's what's kept me here. It's constantly evolving. It's different. It's difficult, and that makes it fun. I sit in Dubai. Dubai has an airport which is the busiest international hub airport in the world. There are flights going to literally everywhere out of Dubai, and that means there is a very, very diverse population. And a very, very diverse range of transactions and disputes coming off the back of them that are going on either in this region or connected to this region. So as we go through the slides, I'll try to draw out some of the stories or the angles that I think are potentially of interest that have some connection to the region, rather than just talk about the possibly slightly dry principles of international law as you might find them in a textbook. But please ask questions, whether it's about the photographs. They're not my photographs. I take no credit for them. I wish I could. Some of them are rather good. Or whether it's about the legal content. So let's skip on to the next slide. So the content, first of all, I'll tell you a bit more about where I am in Dubai, and then we'll talk about some of the general principles of international dispute resolution, which is applicable law, jurisdiction, and the recognition and enforcement of judgments. Those are the three key pillars, if you like, of private international law and international dispute resolution. And then thirdly, some strategic considerations, suggestions that we tend to think about when considering cross-border disputes of this type. And as I mentioned, also when we're thinking about transaction planning with foreign counterparties. Some very brief comments on trends. I mean, these trends are just a few. There are many others, but ones I thought would be useful to draw out. And I've given time at the end for a Q&A, but I'm very mindful that Elliot has explained the arrangements for Q&A, and as I say, please do chip in whenever you wish to. So just to put the region I'm sitting in on the map, if you look hard enough with a bit of a squint, you'll see the United Arab Emirates just to the right of centre in the light blue, dominated next door to its neighbour Saudi Arabia. The UAE is, as the name would suggest, it's an amalgam of 7 distinct emirates or states, I suppose, each with their own royal family that effectively rules the relevant emirate, but brought together under a federal arrangement. It's a pretty complicated legal and regulatory jurisdiction, to be honest, and we'll come back to some of that in due course. But that is all contained within a country that, and I had to look this up on Wikipedia, it's about the same size as South Carolina, so it's not very big. And that is a country that enjoys the 6th largest oil and gas reserves in the world. So it's quite an economic powerhouse now as a result of that discovery and subsequent exploitation of its natural reserves, and that's what has put Dubai and Abu Dhabi literally on the map. Abu Dhabi enjoys about 90% of that oil and gas wealth. Dubai actually has very, very little. Dubai has, I would say, put itself on the map almost despite or because it doesn't have those natural resources in abundance. It's had to diversify itself and make itself distinct from its big brother Abu Dhabi. And the way that it's done that is to focus on tourism, to build a domestic infrastructure that's attractive to bring in foreign investors for financial services, a range of other activities, a shipping hub, to make itself relevant against the backdrop of Abu Dhabi, which controls all of the oil wealth. It's got a population of about 10 million people, and that is interesting because it's made up of only 15% nationals or Emiratis, as they're called. The rest, the other 8.5 million or so, are expatriate workers from a whole host of jurisdictions. Many of them from Southeast Asia, from India, Pakistan in particular, and they're typically focused, not exclusively, but typically focused on the construction sector. And then a lot of professional expatriate workers from Europe, the US, Australia, and other parts of Asia. So it's an incredibly diverse place. To my great regret and embarrassment, I've been here for 12 years. I don't really speak any Arabic. I can manage in a taxi if I needed to, but the taxi drivers aren't Arabs. They'll be from India or Pakistan. I have very, very little Arabic, and it's just not necessary. It's quite a strange thing. The British, I think, are probably well known for being very poor at languages, and it's even more the case here. You just don't need it. If I was to learn a second language that would be relevant in the UAE, it would probably be Hindi or Filipino. They'd be more relevant day to day than learning Arabic in many, many ways. The language of business is English. The language of the courts, however, is Arabic, which creates big problems for many people when they get caught up in the local court system. The working week is Sunday to Thursday, and I've again, after 12 years, I still haven't got used to that. I find that very difficult on a Sunday when all the sport is happening, and I can't watch it because I'm stuck in the office. It makes Fridays quite good, although we tend to get more phone calls on a Friday for some reason from our colleagues around the world than we should do. So it almost feels at times like you're working a 6-day week. And I'm sure, as many of you know, we're currently in Ramadan, so the holy month for Muslims. And again, that has seen huge change. Going back 12 years, I wouldn't be able to walk out to a coffee shop, buy a coffee and walk back to my car or to my office. That wouldn't really be allowed to be done during the daytime. And of course, many other restrictions as well. Now it's almost as though Ramadan doesn't exist anymore, or doesn't matter anymore in the daytime. You can eat, drink completely without restriction around the UAE in a way which was just inconceivable 10, 12 years ago. And I think that's really all around the need of the country to liberalize its economy, to bring money back into the economy in particular because of the impact of COVID. And I suppose on a work note, I do work pretty much everywhere that you can see. I've done disputes in, I would say, all of the countries that you can see on that map. Maybe not Yemen, but certainly everywhere else that you can see. The center of gravity for what we do in Dubai is probably still just about the UAE, but a very, very significant amount of work relates to or is done in Saudi Arabia as well. That is very much the economic powerhouse of the region. There are some enormous infrastructure projects which are going on in Saudi at the moment as it tries to modernize its economy, move away slightly from oil and gas dependence. As of course everyone is trying to do at the moment, but it's coming from a much more conservative place than somewhere like the UAE, which is much more open and internationally focused. One country you can't see on this map, it might be behind where my image appears on the right, can't quite tell, it's probably further over than that, is India. India is one of the biggest trading partners for the UAE. There is a very, very strong business connection between the UAE and India. And in fact, before the UAE became independent in 1971, a little bit before that, the currency of the UAE was actually the Indian rupee. So there's some very unusual and interesting trade connections there around the region. But Indian business is really important. And I do a great deal of work for Indian clients in the UAE and vice versa.
So, Stuart, as you move to the next slide, there, just a contextual question. You referred to UAE as a federation of autonomous regions. Do they have a unified court system there? Is there a federal court system analogous to the federal court system in the U.S.? And are there independent state court systems?
It's a great question. It's a really complicated arrangement. So there is a federal court system. The five of the Emirates are completely within the federal system. 2 of the Emirates have partially their own system that sits outside the federal system, but they can all go up to the most senior court, the Court of Cassation, for any matter. So it's a split picture between a federalized, unified system of courts and some exceptions. That's in relation to the ordinary Arabic language, Arabic written laws system. There is a further complication, which I'll come to when I talk about the Dubai International Financial Centre, which even more adds to the complexity of the legal landscape that we're dealing with. But in essence, the 7 Emirates have a federal system, but with a couple of exceptions.
Thank you.
This picture, I love the picture on the left in particular. This was taken in the 1980s, and it shows the center of Dubai. There are half a dozen tower blocks. The road that you can see running from bottom right to top left is a track in the sand. You couldn't really call it a road. That road is now a 6-lane highway in each direction that has been built over a canal, and it was built over that canal while it never closed. The canal was put in place, it was built under the road was built up and over it, and the road was never closed. The change it's seen is utterly extraordinary. So you can just see a bit of that road to the left of the right-hand picture. So that is now the main arterial road connecting Dubai to Abu Dhabi, the same road that is the sand track on the left-hand picture. You can see in that picture the Burj Khalifa, which is the iconic tallest tower in Dubai and the world, at 828 meters, which is, I believe, about 2,700 feet, something like 3 times the size of the Eiffel Tower. So that just gives you an idea of the scale of change that's happened since the UAE started to seriously develop its economy using this oil and gas wealth that it enjoys, and in Dubai with partly through that wealth, partly through borrowing, to completely transform its landscape, both literally, but also in terms of its social infrastructure and other aspects, going from an economy based upon pearl diving, pearl fishing, and little else, to a highly sophisticated, at least on the surface, economy with financial services, a lot of technology, a lot of very, very cutting edge activity happening, and really putting Dubai and the UAE on the map. So we won't leave information about Dubai there, but we'll move on to some of the legal content and pick up some Dubai and Middle Eastern tales as we go. So the content is really focused on the three topics I mentioned at the beginning, which is applicable law, or governing law as it's sometimes called in the context of contracts, jurisdiction, and then we're talking about what is the forum for your dispute to be resolved, whether it's a court or possibly international arbitration, and which court will a court have and retain jurisdiction over a dispute, and then recognition and enforcement of foreign judgments and awards. So I'll talk about those three briefly, and I'll try to give you some of a flavour of how some of those issues are dealt with, both generally but also in the part of the world that I'm based in. So applicable law, the academics are all very interested in applicable law and the importance of applicable law, but in practice, my view is that it's the less important of the two or three areas of private international law that I've just identified. But obviously, what we're talking about is what is the legal system that will supply the rules that determine the parties' obligations, whether that's under a contract or a non-contractual arrangement, whether it's tort or something else. What is the legal system that's going to apply? Now, of course, most national legal systems will, whether it's in their procedural rules of court or somewhere else, will allow the parties to choose an applicable law other than the domestic law of the forum. But there are many, many exceptions to that. And where of course, you are choosing a foreign law. So if you have a contract between a US company and a British company, you may choose something else for, I don't know, some sort of concept of neutrality. You may choose to have, I don't know, Singapore law govern or something like that if you think that's advantageous. But you're in court in England. The English courts are very happy and very used to accepting submissions on the content, in my example, of Singapore law. They will normally require not just submissions, but also expert evidence. So you'll bring along a professor or equivalent of from a Singapore law school or a university to explain the relevant principles of Singapore law to the English court, and then the English court will make findings of fact as to the content of Singapore law to determine the dispute between the US and an English party, in my example. So that's extremely common, and that is common in most common law systems and many, many civil systems. In Dubai, it isn't. It says it is on the tin, but I'm afraid it's not the case in practice. So the laws of the UAE and many other GCC states say that the parties may choose to have a foreign governing law apply to their dispute. But in reality, it just doesn't work that way. It's very, very rare for a court to actually accept that a foreign law should apply. So in reality, as much as you may try to agree this in advance, the courts are likely, without really giving proper reasons, to apply domestic law in any event. And there are, of course, the other point to note is there are going to be many areas of mandatory application of national law rather than foreign law, even where foreign law has been chosen. So a really obvious example would be an employment contract, where in most countries it's impossible to impose a foreign law on the employee, and therefore any such choice would be void. But one other important area in this region is in relation to agency and distribution agreements. And I've dealt with matters for a number of US clients with arrangements where they provide goods for distribution into the GCC via a Dubai or other GCC distributor. And there'll be an agency or distribution agreement in place that contains sophisticated arrangements as to how the regime should work, fully and properly negotiated. All looks good in theory. When a dispute arises and the agent doesn't like, for example, the commission level they're making, or some other problem arises, or the US or foreign principal decides they want to move to a new agent or to otherwise terminate the arrangements, they bring a claim. Maybe there's an arbitration clause. They start their arbitration, great, or start proceedings in their chosen court, maybe in the US, great. And that all goes wrong, unfortunately, very, very quickly. Because if the agent or distributor is a national of the country in question in the GCC, and certainly this is the case in the UAE and Saudi Arabia, then there will be mandatory application of domestic law that will override the contract, and also almost invariably mandatory domestic jurisdiction with a special agency court that will determine the dispute, that will trump the choice of forum in the contract. So that really is an area to keep an eye on, and where possible to try to structure the agency or distribution arrangement so that it doesn't fall within the scope of those mandatory laws, which is easier said than done, let's say. But there are ways that can be achieved if you take advice on it. So that's a very important area to watch out for. The other point I think to note, and I think this is an interesting trend, I would say, is that over the last probably 30, 40 years, you've seen an emergence of international codes of law, of codified versions of law. So you have various codes that have come out of the United Nations, so standard terms of trading for shipping, for example. You have the UNIDROIT PIC, the Principles of International Commercial Contracts, which are often adopted into new legal systems. So where I work in the Dubai International Financial Centre, where Omar used to work in the same office with me, in that jurisdiction, which I'll come on to, they have created a new jurisdiction, and the contract law is basically modelled on the UNIDROIT Principles of International Commercial Contracts, which is pretty much English common law, but with some civil law variations. So, for example, English law does not have a general concept of good faith, which comes as a surprise to many people. I appreciate that it's a significant difference between English law and most US laws. But they have introduced, by introducing the Principles of International Commercial Contracts as the contract law of the Dubai International Financial Centre, they have introduced a concept of good faith into what is otherwise mostly English law style contract law. And then we have another interesting development, which is the increase of usage of Islamic laws, especially in Islamic finance. So there are multiple Islamic law standards and forms of law based upon different schools of Islam and what should or shouldn't be acceptable or permitted in terms of Islamic law. So, for example, there are, just taking some really basic examples of Islamic law prohibitions, generally interest on debts is not permitted under Islam, nor is gambling, for example. So those are going to be generally void provisions in many contracts that have strict Islamic laws. Not so in the UAE. Actually, interest is allowed in commercial contracts in the UAE, and surprisingly at very high rates. At least 9% would be awarded on general court judgments. But in terms of more sophisticated aspects, there are increasingly more and more codified Islamic finance laws that can simply be imported as implied terms into commercial contracts, and those terms, those bodies of Islamic law, are increasingly sophisticated. And the Dubai government is leading a program to develop an internationally accepted set of standards for Islamic finance laws, which is expected to be published in the next 6 to 12 months. So how important is all of this? Going back to my first comment, of course it is. Of course it's important to know what the law will be that will govern your dispute, and then govern your contract, and then govern your dispute if a dispute arises. That goes without saying. However, and again, an enormous generalization, very often you end up at a pretty similar result under many systems of law. Perhaps a difference on the inclusion or not of good faith seems like a big difference between two different legal systems, but actually English law without a good faith concept or doctrine gets to the same result through a variety of other mechanisms of equity and rules regarding representation. So very, very often you get to the same result without necessarily the same law applying. Now, again, I accept that's a huge generalization, but if you're negotiating with a counterparty over the private international law elements of a contract, so you're dealing with applicable law, choice, and jurisdiction, in my experience, 9 times out of 10, you're better off winning the negotiation in relation to your choice of forum than you are in relation to applicable law. And so I'll come on in a moment to explain why that's my view. So in relation,
move on,
please.
Stuart, just quickly, does the nationality of the parties matter in the determination about applicable law?
It can do. That's a good question. It can do. So again, to take it, I'm conscious I'm talking a bit about the DIFC without having explained what the DIFC is yet. But in the jurisdiction I sit in, if there is no agreed governing law in a contract or a dispute more generally, there is written into effectively the procedural rules a set of criteria that the court can apply to determine the applicable law. And one of those, one criterion is the nationality of the parties. So yes, it would be a criterion, not necessarily determinative. More often, as a general rule, and certainly this is the case in the European Union, that has a very sophisticated regime for the European Union states in relation to determining jurisdiction and applicable law. The focus is much more upon where in relation to a contract, where was the key contractual obligation that characterizes the contract to be performed. So if it's a contract of supply of goods, where were those goods to be supplied? If the parties have not agreed the law in the contract, then that place of supply is likely to be identified as the place that should supply the governing law of the contract and of the dispute.
Understood. Thank you.
In relation to so the second limb of our private international law considerations, jurisdiction, we've got 2 or 3 different concepts to compare and contrast. The first is which court, choosing a court. The second is whether you should choose court or something else, which basically means arbitration. And thirdly, which I won't really touch upon today because it's outside the scope of what I can sensibly cover, is international investment treaty arbitration. In relation to the first, which court has jurisdiction, again, you're going to be looking at where the parties are based. So very generally, you can sue a party in their home jurisdiction. So if you have a claim against a party in Spain, then you're very likely to be able to bring a claim in the Spanish courts against that party. Again, assuming you haven't agreed something in your contract that precludes it. So that's the standard position, but you may also be able to bring a claim elsewhere, absent choice, such as possibly where the breach of contract or the tort or whatever it might be occurred. So there may be options, and so that immediately means you're looking at strategic considerations. Which is the best place to bring your claim? And again, we can't really go into that in any detail now, but some obvious factors that you'd be looking at considering, and also when you're comparing a choice of court, as well as whether to write an arbitration clause into your contract, would include how comfortable are you with the court's independence? Are these courts sophisticated enough to deal with the dispute that you have? Do they have the subject matter capability for a complicated construction contract or financial services contract, for example? How long do the courts take? Is this India, where court proceedings can take 10 years or more? What are the court costs? What are the lawyers' costs in the jurisdiction? What is the language? Can you deal sensibly with that court in a foreign language when you have to go through interpreters or local lawyers? All of those sorts of considerations. There's a whole host of considerations to think about. I think the key one, other than obviously independence and capability, is going to be around enforcement. If you end up with a Spanish court judgment, but your counterparty is not in Spain anymore, they've moved, even though they were there to start with, or maybe they're incorporated there, but their assets are somewhere else. What used to you is a Spanish court judgment. So always thinking about enforcement is absolutely critical. And of course, courts have very complicated rules regarding whether they'll accept jurisdiction. So there may be a tenuous connection to a court, and you may be able technically to engage the court's consideration of whether it has jurisdiction, but then you need to retain jurisdiction, often in the face of a challenge from a counterparty or a skeptical judge. So very often, even if in some cases where the parties have agreed that a court should have jurisdiction over their dispute, the court itself can decline jurisdiction where there isn't sufficient connection to that territory. So these are inevitably complicated and multifaceted issues that go well beyond the scope of what we can cover today. But the key takeaway is that you should be thinking about this when you're drafting, thinking about the counterparty, where they are, where their assets are, where do you want to sue, but also where do you think, if you're going to be sued, you want to be sued. And that's often overlooked when thinking about choice of forum. International arbitration, obviously founded on party consent. So if you haven't agreed that in your contract at the outset, you would need to agree it when a dispute arises in order to submit your dispute to arbitration. And the big advantage, and what justifies or what explains the incredible proliferation of arbitration, international arbitration in the last 10, 20 years, is the fact that there is such good enforcement internationally of arbitration awards, in particular as a result of 140 plus countries, I can't remember the exact number, being a party to the principal enforcement convention, being the New York Convention. And so we are very often dealing with disputes at the enforcement end only, where a client will come to us and say, we've got this award, we're now looking to enforce it in the UAE or in the wider GCC, please help us. And then you're into a question of how best to strategically to enforce that award in the region, and all the local pitfalls and cultural issues that need to be navigated to do so. And as I mentioned very briefly, international investment treaty arbitration, that is almost a specialism within dispute resolution of its own. We have a team that does that in a number of our offices, but it's not something that all of our disputes lawyers would do because it is quite specialist. So there we're dealing with international treaties between countries that stipulate that in the event that an investor from country A makes an investment into country B, they will receive certain protections in country B that would be pretty much equivalent to the protections afforded to a national of country B, and many other things. So, for example, that there wouldn't be a change in law adverse to nationals of country A in the future, other such things, and would give a right to access a specialist arbitration centre in the event that there is a dispute between the parties, between the foreign investor and the domestic party. So it creates a sort of specialist hybrid form of dispute resolution based upon some bilateral and some multilateral investment treaties, which have their own, they're very much their own beast, and increasingly common where the domestic courts of a country are simply failing to provide due process, to provide a fair process to foreign investors. They are elevated. They can be elevated to, after you've exhausted domestic proceedings in the country in which your investment has been made. After you've exhausted those steps, you can then take it up to, if there is a treaty in place, the arbitration forum that treaty provides for.
Stuart, as you transition, two questions. One is from Roman Rewald. Roman, would you like to articulate your question?
Certainly. It seems like the environment is prompt for mediation, because the dispute might not be resolved that easily. So the question is mediation ever used? And if there is any law that would allow confirmation of mediated resolutions, agreements, if they are mediated and then submitted to the court for confirmation.
Thank you, Ronan. In relation to the first point, mediation is not as popular as it should be, or as I would like it to be, in the Middle East. There is, I would say, a culture of exchanging, of negotiating right at the outset of a problem arising, and if that doesn't result in a settlement, then going to court, and then probably no meaningful attempt to settle afterwards. That you very rarely see ongoing efforts to settle during a dispute once it's into the court or arbitration process where there are regional parties involved. So the use of mediation, I'm afraid, has not really caught on very much. A mediation centre was set up in Dubai about 7 years ago. I'm actually still on the founding board of it. I haven't done one mediation through that centre. So let's say there's room to improve. That's probably the best way of characterising it. There are a number of arbitration centres in the UAE and the wider region. They also have their own mediation branches or wings under those arbitration centres, and they're not very busy. There are some very good mediators out in the region. It's encouraged, but there just hasn't been the take up, which is a shame.
Thank you.
Thank you, Stuart.
I'm going to skip on a bit quicker now. I'm conscious of time. So enforcement of judgments. Look, I mean, the real point here is, you've got your judgment in New York, in Detroit, wherever it might be. You want to enforce it in Dubai. How do you do that? Will a court recognise it? Is there a treaty in place? This gets extremely complicated, and of course, you have the risk of conflicting decisions from different courts. And I've put on bullet point 3 what is delightfully known as the Italian Torpedo, the race to get a case into a court first. And once you've got a case in a court, then typically a second court seized will defer to the first court. Certainly within the European Union, that has been the case. So this whole area of recognition of foreign judgments, of enforcement of foreign judgments, is difficult everywhere. It's particularly difficult in the Middle East because of the problems with a lack of treaties for the recognition of foreign judgments. So whereas you have the arbitration regime pretty good, uptake of the New York Convention and other regional conventions for recognition of foreign arbitration awards, there isn't anything like the same position in relation to judgments. And so you have to effectively bring a new claim, relying upon the foreign judgment as a factual matter to seek enforcement. So I won't say much more about that now. I'm very conscious of time. I would say that in relation to the Middle East, this is an area that again has room for improvement, a bit like the uptake of mediation, but there has been a bit of an improvement. So one area where things have changed in my time in the Middle East, when I came out to Dubai, you would see all sorts of ridiculous objections being made by respondents to the enforcement of arbitration awards and foreign judgments that would succeed. Things like an arbitration award not having the name of the Emir of Qatar or whichever state it would be written on the top of the award, or it not being stamped in the right place, or something like that, and that would be an argument that would get traction when it came to enforcement. I think now the judges even in the domestic courts are so much more aware of and supportive of mediation and of foreign judgments and matters, that those sorts of arguments are getting less and less traction. But it's still a challenge, which again requires that thinking to be done much, much earlier to make sure that you don't trip up on these things when it's too late. A bit of light relief. The Dubai courts. Now, I've mentioned the DIFC a few times. Dubai is one of the 7 Emirates, so it's small, but it's a state within the UAE. There is also the city of Dubai within the Emirate of Dubai, and I'm speaking to you from my home in the city of Dubai. Within the city of Dubai, the government carved out a physical bit of territory and called it the Dubai International Financial Centre, and it's one of over 30 distinct zones called free zones or commercial trading zones that do a specific thing. And this one, of course, as the name suggests, is focused on international and financial activity. And that's where our office is based. And they have created their own legal system in the DIFC. So all of the civil and commercial laws that apply in the rest of the UAE do not apply in the DIFC. So you cross the road from one side to the other. And on one side, the contract law is Arabic written civil law. The other side, it's what I mentioned earlier. It's English language, mostly English common law based law. And there is a court system, a common law court system called the DIFC, Dubai International Financial Centre Courts, that deals with matters that have DIFC jurisdiction. So on the left, you can see the outside of the Dubai courts, these old-fashioned, managed to get a palm tree in there as well, the Dubai courts. And on the bottom left, you'll see the inside of a courtroom, and the back of a courtroom, I think, is maybe being used for training purposes, probably not showing a live case. But you'll see the gentlemen in their robes, the Emirati kandura, and the ladies in the foreground wearing the abaya, the headscarf, and a gown. On the right, you'll see the DIFC courts. I couldn't get a good picture of the inside, but it's like a court that you would find in the US or the UK. And the judge, as you can see, not an Emirati. He happens to be from the UK, wearing his typical English style court robes. So the difference is very, very stark in terms of those two court systems. Now, that court system, why was it built? Why is the DIFC there? Well, it's to bring in foreign investment. It's to give people, the clients that you and I serve, confidence in investing in the UAE, investing in Dubai. You don't really you don't feel too comfortable if your court system is going to be the one on the left. It's Arabic language. You don't know the language. It's unknown. It's unfamiliar. But perhaps this English common law style system is going to be a bit more attractive. So, and it's been an outstanding success. It's just grown and grown year on year, and it has really helped with the growth of Dubai more generally. So much so that there are now a lot of people bring their foreign judgments to the DIFC for enforcement or recognition, even when there's no connection with the DIFC, and they use a protocol or a memorandum between the two courts to take that DIFC recognition order to the courts of Dubai to get enforcement in Dubai, but bypassing a substantive review of the foreign judgment by the Dubai courts because it's already been reviewed by the DIFC court. So it's a pretty cheeky way of avoiding the troublesome, difficult, worrying scrutiny that the Dubai courts might impose over a foreign judgment and the risk that it wouldn't work. That has been so successful, the use of the DIFC to do that it's now been pretty much stopped with a tribunal created a few years ago that would determine which court an application for enforcement or other types of cases that could go to either court should be heard in. So there's this own little jurisdictional conflict going on within the little emirate of Dubai over which courts should have jurisdiction in relation to international matters. Now I'm straying into my last 10 minutes. So I wonder whether, I'll pick out one or 2 points and then I promise I will stop talking and open up the floor. I think the key takeaway is in terms of transaction structuring is always think about how you're going to enforce before you put pen to paper, because if you can't do that, then the paper isn't worth very much. And that to me is all about where is the counterparty, where are their assets, doing that due diligence, doing that thinking. Don't think home jurisdiction works. That just means you're more able to be sued in your home jurisdiction. Doesn't mean you can then enforce your home judgment in the country of the counterparty. So you really do need to think about that very, very carefully. I've put at the bottom here asymmetric and multiple options in DR clauses. You may be able to agree that you can bring proceedings in more places, different places to your counterparty. That gets quite complicated, but it's a thing to think about if you think you've got that negotiating power. And we do see lots of those types of clauses for Middle Eastern matters, especially in the financial services context. So when disputes arise, again, there's too much here for me to cover in detail. I'd like to pick out 2 points. Intelligence gathering is extremely hard in the Middle East. There's a strong culture of privacy. There are no federal company registries, so accessing information about companies is very hard to do. Accessing financial information is very hard to do. You're going to need to work with lawyers, with intelligence firms to work out the matrix of information that's available to you through source contacts and similar. It's a difficult environment to do that. So thinking about that, being smart about that is really, really important. Third bullet point, I was acting recently for a US client, and the dispute got pretty intense, and the counterparty, an Emirati, started criminal proceedings against a senior staff member of my American client, and involved in being arrested and detained for quite a few days. The use of criminal proceedings in what should otherwise be a civil and commercial matter is far too common and a real issue. So you've got to think about that, how you protect your employees from arbitrary action by the authorities, by parties who are looking to use any levers they can do to put you in a position of weakness, knowing that you're a foreign investor. And I do a lot of that kind of work. It's far too common, I'm afraid. Those are the points I really wanted to draw out from that slide. The others are on the slide, and very happy to take questions about them. On the trends, I will just say a couple of things. I would say in this region, what we have seen over the last few years is an enormous increase, even though it's a small region, in more and more international courts like the DIFC that I mentioned. There's a similar one in Abu Dhabi. There's about 6 arbitration centres just in the UAE. So the range of options and the complexity, putting aside the fact that you've got 7 emirates with mostly federal but not entirely federal systems and different regulatory regimes within the same country, means you really need to understand how things work on the ground to choose the right centre, to make sure that you're thinking about enforcement in the right way. It really is a bit of a minefield at times. And some of these other things are, I think, trends. I mean, we all know about technology, how it's changed so much in the way that we do disputes. Recently, I talked about investment treaty matters, a huge increase in fraud matters, probably due to the economic impact of COVID. and the position that the banks are all in. But there's been a lot more fraud work I've seen recently, cross-border fraud work. Data privacy, data breaches, very, very strong trend as well. Very weak corporate governance in the Middle East. People that aren't necessarily skilled enough for doing compliance roles, or they come in the role, they leave too quickly. Lots of churn of employees. So corporate governance is weak, which means that companies are exposed to data issues. And a lot of issues around energy and climate change, given the nature of this region being so focused on natural resources, and an increase in disputes around and increasingly focused on class actions around issues concerning companies not delivering on their climate change responsibilities. So that's a whistle-stop tour. Thank you very much for your patience. I'll end with a nice picture of the Dubai skyline and the Burj Khalifa. And I'm very, very happy to take questions in what I'm afraid is only a few minutes left, but thank you for your patience.
Well, thank you for all the information, Stuart. I'd like to begin with a question from Andrew Morganti. Andrew, would you like to articulate your question? It has to do with the absence of an arbitration agreement. Andrew, are you there?
I am. Thank you. Yeah, so I do primarily cross-border, but maybe a third of my work is transatlantic shareholder disputes. And we don't have, more often than not, rarely have arbitration agreements contained within the investments. And curious to learn what has been in your or Herbert Smith's experience in encouraging adversaries or opposing parties to engage in arbitration, opposed to going through a publicity of a court proceeding.
If we're dealing with a private structure, so sort of a private investment fund or something with a relatively small number of shareholders, of investors, then on the whole, very positive. Certainly in this region and the UK as well, actually, the uptake of arbitration, of international arbitration for those sorts of structures is very positive. I don't see any significant disadvantage to that in relation to resolving those sorts of disputes, apart from one, and that is in this region, even when you get your arbitration award, if you're dealing with something that requires a transfer of shares, imposing that on the counterparty typically requires both parties to attend the company registry or Ministry of Commerce to effect the share transfer. So compelling a party to actually do that on the basis of an arbitration award may well require additional steps to get court orders, etc., to make that happen in practice. But apart from that enforcement aspect, I would say that international arbitration is becoming probably the default for private investment structures of the type you've described.
Excellent. Well, thank you.
Are there other questions for Stuart from anyone in the audience? If you have a question, feel free to pipe up. Hearing none, I have a question, Stuart, which is, are most countries in the Middle East parties to the New York Convention, and are there any notable exceptions?
That's testing my memory, I'm afraid. The answer to your first question, which is easier, is absolutely yes. The second, I'm afraid I tell you what, Omar might know this, but there are a few in the region that are not, and some have only signed up recently and with some exceptions. So I'm afraid I'm going to have to pass on the second question, but certainly the majority of the GCC and wider Middle East jurisdictions are a party. I think Yemen is not a party.
I have a question. Can you comment on the differences in cost between arbitration and the financial center court, and also what arbitration rules are normally selected, or is ad hoc arbitration the norm?
In relation to the first point, there's always been this myth that international arbitration would be cheaper than a court because you can control the procedure. In my experience, that's simply not true. International arbitration, with all of the centres that I deal with and have experienced, tends to be quite expensive. And of course, if you're dealing with 3 tribunal members rather than 1, even more expensive. So I think that it's a bit of a myth that arbitration can be cheaper than court litigation. In relation to the DIFC, there is a fixed fee schedule with caps that it still makes it relatively expensive. I mean, some courts, obviously, as a matter of policy, the courts are deliberately very cheap and they're funded out of general state budgets. The DIFC court is not in that category. It charges on an almost commercial basis, but it's still subsidized. But it's certainly cheaper than international arbitration. And the fees are a bit like arbitration, payable through the course of the proceedings, but with the main fee payable upon issue of a claim. And then in relation to
I'm sorry, go ahead.
I'm sorry.
Gentlemen, I'm going to break in just for a moment to say that we've reached the top of the hour, and I understand that some people will have to drop off. If you do, you can watch the rest of this for however long it lasts on the recording, which Thomas Guy will publish in a raw form, probably right after this meeting, and in an edited form, maybe tomorrow. So I want to quickly thank our presenter, Stuart Paterson, for his time today and the wonderful information. It's been a wonderful exposition of the way that a person can do business successfully, practically, efficiently in the Middle East and elsewhere. And thanks for articulating a lot of the nuances and considerations that one would have to take into account. With that, I want to let Stuart know that you're free to go. We don't intend to keep you past your scheduled time here. If you want to continue to comment, of course, you're free to do so. So with that, I'll turn it back to Stuart.
Thank you. I can continue until 10 past the hour. So I'm very happy to field more questions if there are more.
Bob, did you have a follow-up?
Yeah, just the second half of the question with respect to ad hoc arbitration versus arbitration rules prescribed by one of the major arbitration organizations.
Yes, there is very, very little ad hoc arbitration taking place in the region, where you have a party that is based in the region, and there is no arbitration clause pointing to no arbitration clause in the first place, then that regional party will be delighted to have their case determined in the applicable local court. So that they will see that in a rather unsophisticated way as home advantage and be happy to litigate in a court. It's unusual where there is an arbitration clause to not choose an institution. And I think that's absolutely right. It does increase the costs generally, but it does mean that you've got that element of quality and control over the process to make sure that the arbitration runs smoothly. And there are a number of institutions in the region that are pretty good. Probably the most reliable is the DIFC LCIA. So the LCIA is the London Court of International Arbitration, and the DIFC has exactly the same rules, but the word Dubai written before them in all instances, and they collaborate very, very closely. So you're getting top quality rules. The DIFC as a jurisdiction has its own international arbitration law that is international standard. So if you need assistance from a court to supervise your arbitration, if there's an issue with an arbitrator not being independent or some such issue, then you have a very strong court system and a strong arbitration law to support your arbitration. And as I say, the DIFC LCIA is a very good institution itself as well. So there are many other examples that aren't as good, that are much older and less reliable, but you can find a strong institution here. And we write into our own contracts, our own engagements with clients, DIFC LCIA arbitration most of the time.
Thank you.
Other questions for Stuart? Stuart, one. So you mentioned in the course of your talk implied terms, which is always disturbing. That terms can be implied that aren't in the contract, and to understand when that might happen. I guess where is the risk the greatest of that? And probably by choosing arbitration, you are insulating yourself from those implied terms, because the national court systems are not at least taking first crack at the case. But when is that most dangerous? Are there some gotchas to watch out for in the area of implied terms?
Yeah, it's a difficult one. I mean, in terms of my comments around Islamic terms, then that's usually done by some reference to this. So you often get the formulation, "This contract shall be governed by English law and the rules of the Sharia," so something like that, which is hopelessly difficult to interpret and make sense of. So what does that mean? The rules of Sharia, when you're being asked to look at that alongside English law. And there are various cases in the English courts and elsewhere as to what that means. And generally it means that it's just English law. What you also find, though, is the parties will say sometimes this contract is governed by whatever law it might be, Dubai law, and the commercial terms governing the product. Let's say it's an Islamic loan agreement. Shall be those set out in standard number XYZ. So those are written terms that can be found by going to a website that contains a standardized set of Islamic loan terms, and those are then imported into the agreement and will supplement the express terms of the agreement. So provided that is done clearly enough and there isn't inconsistency, and that's the key thing, between the express terms and those that have been imported by reference, then a competent court should be able to make sense of it. But that is very much an evolving picture, because at the moment we still see too many contracts, especially in the Islamic finance space, where there is this inability to properly articulate express terms versus imported but supposedly standardized terms. So I'm not sure that's a very good answer to your question. It's getting better, but it's a particular concern in the context of Islamic finance.
Thanks for addressing that. So we have 2 minutes and one question, and I think that we'll put those two together and then we'll wrap it up. And this is from Liz Storm. Liz, do you want to present your own question?
Hi, Elliot. Thanks. And thanks, Stuart, for providing us with some insight into international arbitration laws. I don't have much to say. I don't know how to articulate this question. Do women wind up finding that they have to get an agent in Dubai to represent them, or are they allowed to represent themselves under Sharia law in Dubai?
It's a very good question. Dubai and the UAE is much more egalitarian than many other parts of the region. So in relation to personal status matters, so family matters, divorce, etc., then as with any other area of law, to be honest, you have the right to go to court and to represent yourself, or through a male or female lawyer as you wish. All of those things can be done. There are no restrictions on, appearing in court based upon gender. There are no restrictions of that sort at all. The UAE has I think, been at the forefront, certainly in the GCC, in promoting women's rights. There are still some things that are pretty backward. So, for example, my wife works every year when she renews her visa, because we all live here on the basis of a residency visa. We're not entitled as of right to stay in the country as expats. We will never earn that right. But every year, I have to sign a letter saying that I give my wife permission to work. Now, that is ridiculous and embarrassing, but it's a lot better than many other countries in the region that have much more restrictive approaches. So, for example, only a couple of years ago did Saudi Arabia legalize women driving. On the flip side, we have the UAE cabinet has more female ministers than male. There have been a number of female ministers that have been in place for many, many years and are extremely successful. So, on the whole, the promotion of women's rights in the UAE is pretty good and getting better, but with a few aberrations.
Liz, thank you for your question, and Stuart, thank you for your answer and for your entire presentation. With that, we'll call it a day. I wish we could listen to you for so much longer. It's that picture there you have it's just breathtaking in comparison to the earlier picture that you showed with the sand and the nothingness. And now you have this gleaming financial capital. It's hard to comprehend. But thanks for giving us a flavor of that place and how things are done there and in that region of the world. Stuart, it's been a pleasure to spend some time with you. Thank you.
Well, thank you very much. It's been a pleasure for me as well, and thank you for hosting Elliot and Omar, and thank you everyone for your questions and for your kind attention. Have a good day, everyone.
Good day to all. I'll hang on in case there's any follow-up questions or